Greetings. This is Tex. Welcome to thctrust.org. Tonight I want to talk about administrative procedure. I'm not going to get into the full scope of how you um, do an administrative process from start to finish. This conversation assumes that you're somewhat familiar with an administrative process, and I'm just going to point out some things to make you aware of that may make your administrative process even stronger and more enforceable. If you wish to learn from the beginning of what an administrative process is and how to perfect one the right way to make it enforceable and to get the desired results that you're looking for, then visit www.thctrust.org and click the link that says Administrative Procedure under the Topics menu, and there is a in-depth video, which is the best that I've seen so far, and it's done by Brandon from Creditors and Commerce, and he explains how you do the administrative procedure. I'll start out by talking about one that I have before me right now, which is something that I was involved in actually. There's a vehicle that belonged to our trust, and I'm one of the first trustees. And long story short, the vehicle was impounded. It was impounded and it was towed. And when we showed up to get the vehicle, we were told that, oh, well, you have to register it with the state of Georgia and this, that, and the other. And it wasn't the intentions of the trust to register that vehicle with the state because it's property of the trust. So, anyways, when we went to retrieve the vehicle, we've provided the bill of sale and all the necessary information regarding the trust and who I was as the trustee. And we were requiring them to release the vehicle. And they were like, oh, no, well, we can't release it until you register it with the state. So, in that particular circumstance, I requested to speak to the person in the authority position that was on duty at the time. And a police lieutenant came out. And when he came out, I said, sir, may I speak to you in private? And he said, sure. So he took me over into a small room and he had some other individuals with him. And I said, I would like you to know that I'm accepting you on your oath of office and your indemnity bond in regard to assisting the trust in resolving this matter, whereas you guys are holding on to a piece of our property and you're requiring that we register it with the state of Georgia before we release the property. So I pretty much told him that I needed him to supply me with some citation of authority or either a written court order or uh, something written from a bonded official from their organization validating or certifying their authority to withhold the property. And he couldn't provide me with that. So I said, well, I'm going to need you to provide me proof of your authority to withhold our interest or the trust's interest in its own property. I said, because in the absence of your ability to provide me with any authority to do so, then that constitutes your agreement to compensate the trust for $5,000 per hour for every hour that the property is not within, our possession. Well, he laughed at it. He thought it was funny, as they typically do. And, I didn't have no guns, no firepower. I can't fight them. So what I did, if you guys recognize, I just made a verbal contract with him. And he said, oh, ha, 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 we're not paying you $5,000 an hour. And we don't agree to that. I said, oh, yes, but you do agree to it because you haven't provided me with any proof of your authority to withhold the trust's property, and you haven't returned the property to us, and you agree that it does belong to the trust. So your failure to provide your authority to do so constitutes your agreement that you will pay $5,000 for withholding the trust property. This is in accordance with your behavior. See, that's tacit acquiescence. What I was doing is I was creating a contract with them in real time. So how that ended up playing out is I ended up leaving and I left and I went home. And as soon as I got home, I typed up a document called a memorialization of the agreement. And this is essentially, it's just worded differently, but essentially it's the same thing as an affidavit of fact, because the first thing in the administrative process is you have to lay the groundwork, the framework, which is the facts of the matter of what actually occurred. And I have it sitting here in front of me. I won't read through the whole thing, but I'll paraphrase. And it basically says, just as I told you. It says, so it's a memorialization of the agreement. And it's expressed in the form of an affidavit. And it says background. On such and such day, it talks about, when they took possession of the property. And it goes through the whole story. But the most important thing is it expresses in here that an agreement was made with Lieutenant John Doe that his inability to provide, it goes through everything. He was accepted on his oath of office and required as a trustee to provide a remedy for them withholding the property without proving the authority to do so. It also expressed that there was an agreement. It didn't say I asked any questions. It says there was an agreement established between myself as the first trustee on behalf of the trust and Lieutenant John A. Doe that the lieutenant agrees to pay to compensate the trust $5,000 per hour for every hour that they're withholding the property for their inability to provide proof of their authority to do so. And when I did that affidavit of truth, a plain statement of fact, memorialization of the agreement, I sent it to him. Now you have to look at this from his perspective. When he got this document saying that there is an agreement in place in accordance with the statement that I made under oath, what can he say? Because he clearly remembers having the conversation. There were other people in there. So now he's in a tough position because he can't come back and say, oh, I didn't agree to pay them $5,000 per hour for holding on to the property. Because he can't say that unless he can still provide proof, unless he can hold up to his end of the offer, which is the only way you can not give the property back and continue to hold on to the property is either you pay $5,000 or you provide proof of your claim in the form of a court order or some type of bonded document certifying the authority to withhold the property. So he couldn't do any of that. So essentially, the only thing he could do was sit there and acquiesce not only to the verbal agreement, which he already did, but also to the memorialization of the agreement, which is the contract that I sent him. So he defaulted on that. Okay? And remember, he laughed when I first presented the offer to him. So he defaulted on it. And once he defaulted, I waited till a good 10, I gave him, I say, hey, you have 10 days to respond to this memorialization of the agreement, to whether, to rebut or provide your own statements on a point-by-point basis to invalidate this, basically. And there's technically nothing he can say because you can't answer that unless you go under oath in writing and provide your proof of authority to withhold the vehicle. And there is no law that says that they can withhold property. There's no law that says you're required to register anything. So he defaulted to those terms. And after he defaulted, I let the bill run up till it got about $2.4 million, and I sent him a bill for it. And he defaulted and he didn't pay. And I sent him another bill. And all this was done by notary presentment, which is a key part of the administrative process. You must do this through notary presentment. You can get around not doing it through notary presentment, but if it's something that's very important, that may get a lot of eyes when you perfect it, then you got to do it. And when the process got boring and it got blurry and I couldn't see the light at the end of the tunnel, I had to be persistent and continue to follow through the process. That's the thing. You can't be lazy with this. If you embark on this journey, you got to follow it through to the end. So now after he's defaulted on it, now he's got a serious problem on his hands because now this is in the mayor's office and it's at the chief of police office, and I've received a couple of telephone calls of people trying to contract me out of my position, which is not going to happen. Now this is like 90 days later, and now he's got a serious problem on his hands because again I've given him, and that's the thing with these administrative processes, you have to give ample time. You let them know where you're going with it, and they can laugh all the way until it becomes a serious issue, which they have a serious issue now. I take my administrative processes, which is something I'm going to talk about in this video right here, and I get them witnessed by the notary. I get them. I get them certified by the notary. I get a witness on the notary seal, and then I get it authenticated at the Secretary of State's office. So now, whether I file a lien or I take this claim out against the person's bond, no one can challenge this, because it has, you know, 3 witnesses on it, and these witnesses are officials of the state. So in order to challenge the validity of this claim, you're going to have to challenge the notary, you're going to have to challenge the clerk of the Superior Court and the Secretary of State. So this is a very powerful document, and somebody's going to have to deal with it. So I'll keep you guys updated on how that turns out. But for now, let's talk a couple of details about administrative procedure. And again, remember, if you want a detailed detailed instruction that tells you how to do the administrative procedure, then make sure you go to thctrust.org and click the administrative procedure link and watch the hour's worth of videos there. And I highly encourage that you learn this process, because I don't go to court. I handle as much as I can outside of court, and that's what you should do, because if you can do this administrative process, you will be able to resolve almost anything, from speeding tickets to mortgage issues to it's unlimited. But this is how you deal with things without having to put your face out there, without having to subject yourself to the games and the sideshow that takes place in the public court. Now, to learn how to do a proper administrative procedure, visit thctrust.org, click the administrative procedure link on the left side of the page, and there will be more than enough information, including some videos that take you through the step-by-step process of doing an administrative procedure by way of notary presentment. And the full scope of the notary presentment is also explained there, and there's also template documents that I'll have there, so you will know how to prepare the notary's certificate of service and the notary's cover letter. But the purpose of administrative procedure, for anybody who may not know, is the administrative procedure allows for you to resolve your issues prior to going to court or without going to court. And if you are one of those people that just feel you have to go to court anyway, then by first perfecting an administrative procedure, you don't have to go in there trying to argue or convince the judge to see your position, and you really don't have to be subject to the different games and the jurisdictional games that they may try to play, because you would have already have established the facts, of the record that you need to establish. So you don't have to go in there, argue, or prove no point. And again, that's why a lot of this video is going to be directed at how you use the administrative procedure when you finish with it. Now, the first thing I'll say is, when you do, everybody does these administrative procedures, but I would highly recommend that you make sure your administrative process is conforming to the timelines and the procedure that's set forth in the Administrative Procedure Act. And that's in Title V of the United States Code, somewhere around Section 530. The whole Administrative Procedure Act would be at thctrust.org for you to download under the Administrative Procedure link. But I highly suggest, now you're not required to use the timelines and to bring your process in conformity with the Administrative Procedure Act, because all those public laws, statutes, and codes apply to those that are in the public, which means the public officers and the trustees, etc., etc. However, because we know that they're required to follow those statutes, and we know that that the Federal Code of Regulations apply to them, then we want to make sure that we speak a language that they can understand, so that there could be no excuse as to why they didn't honor our process or our consent judgment, because essentially that's what our administrative process is doing. It's establishing the facts and when those facts go unrebutted, they become a consent judgment.